Good morning, everyone. Welcome to our webinar on the Employment Rights Act 2025 and its implications for those of you who engage different kinds of casual workers, namely uh, workers on 0 hours, low hours, and agency worker contracts. I'm Graham Green. I'm a partner in the employment group at Pennington's. I joined Pennington's last month, um, prior to which I practiced employment law for the last 25 plus years in London. I'm based in our Cambridge office and our London office. I'm joined by Katie Harris, who is a senior associate in the team. Katie has a particular interest and expertise in all things labour supply and employment status. And Katie will cover the guaranteed minimum hours section of this webinar. I'm also joined by Janie Smelly, who is an associate in the team as well. Janie will cover the reasonable notice and shift changes part of the webinar, and I will then look at the expansion of protections for workers arising from the new legislation, some intended and possibly unintended consequences, including a brief look at unfair dismissal rights. These provisions on 0 hours, low hours, and agency worker contracts are due to come into force next year. The consultation on the provisions was due to be published in the autumn of last year, but the consultation hasn't yet begun. As it stands, therefore, these provisions could be introduced next year, very shortly after the end of the consultation period. On that basis, we feel it's important that you think now about how this impacts your organization and your workforce, and consider maybe taking some of the practical steps that I'll cover at the end. We'll deal with a brief Q&A at the end as well, so feel free to add any questions you have to the Q&A as we go along, and we'll pick them up at the end. I will now hand over to Janie to cover reasonable notice of shift changes. Janie.
Thank you, Graham. Hi, everyone. Yes, so the Employment Rights Bill is going to introduce a duty for employers to provide workers with reasonable notice of shifts and cancellation or changes to shifts. The new protections are designed to support workers with unpredictable and variable working patterns, but they are most likely going to cause problems for industries where flexibility is needed to meet the demands of a business. And I think the hospitality sector is going to be particularly affected by this. The protections apply to workers who are offered shifts on 0-hour contracts, workers on flexible contracts where varying shifts are offered, and it is also going to be extended to agency workers, though some shifts aren't going to be included as they'll be classified as excluded shifts. We don't know what excluded shifts mean yet, but it's suggested that they will relate to highly paid work, very long hours, very long shifts, and pre-scheduled contracted hours. Until the regulations are finalised, though, we recommend that you consider all shifts to be covered by the regulations. So what will the new rules be? An employer must give reasonable notice of a shift specifying the date, the start time, the end time, and the number of hours to be worked. Unless this information is given, it will be presumed that notice is not reasonable. The employer must also give reasonable notice for cancelled or changed shifts. An employer must make a payment of a specified amount to a worker each time that the employer cancels, moves, or curtails a shift at short notice. The specified amount isn't yet defined in the regulations, but that will be something important to look out for. The duty to give reasonable notice of a shift doesn't apply where the worker suggests working a shift, but once the shift is agreed and in place, then the duty to provide reasonable notice for cancelling that shift or changing the shift will apply. The duty to provide notice of cancellation or changes will most likely apply to when shifts are extended, but it's not yet clear on that point. If an employer offers a shift to multiple employees, this is known as a multi-worker request, and multiple employees say yes to that shift, but the shift is only given to one employee, then cancelling the shift for all of the others that agreed to work the shift will be caught under the regulations, and that's going to make multi-worker requests really quite difficult. I know that when I worked in hospitality, those types of shifts would just be given out to anyone, and it's a free for all. So I think that will be quite tricky for hospitality industries specifically. It isn't envisioned, though, that employers will be penalised when two workers agree to swap a shift. I know, again, from personal experience, that can be quite common. We don't know yet what reasonable will mean, and this will be subject to consultation. A think tank organisation has recommended to the government that reasonable notice should be set at 2 weeks. However, until the regulations are set, we won't know. The above duties will be extended to agency workers, and the duty will apply to both the hirer and the agency, and whoever causes the failure will be liable. The hirer, so for example, if a hirer tells an agency of the cancelled shift that the agency then doesn't pass that on to the worker, then the agency will be liable. Workers can bring claims for failures in the employment tribunal, and if successful, an employment tribunal must make a declaration to that fact, and also they may make an award for compensation. Compensation is going to be what the tribunal considers to be just and equitable in the circumstances to fully compensate the worker for their financial loss sustained. It's likely that this will be a minimum of the specified sum that's going to be defined in the regulations, but also it's likely to include the loss of earnings from the shift, travel costs, and loss of other work commitments, among other things. The usual duty to mitigate losses will apply, and a worker will also have the right not to be subjected to a detriment by their employer in a situation where they refuse to work a shift on their belief that the employer did not give reasonable notice of the shift. These regulations are looking to come into force in 2027, as Graham has said, and it's important to take practical steps now to prepare. Organisations should be looking to audit their current practices. So how much notice is currently being given for shifts? Can more notice reasonably be given? And what is the common reason for shift cancellations? It will be important to put steps in place now to reduce avoidable cancellations. And also it will be necessary to review the current workforce structure, so assess how staff are allocated across roles and shifts, identify opportunities to improve flexibility without last-minute changes, and consider whether the staffing levels or resourcing models contribute to those cancellations and what can be done to improve them. Workforce planning will be very important, and it's useful to get this all sorted out now before the regulations come into place. So analyse patterns of demand. What are your busy periods? What are the seasonal trends? Use data to plan rotas more accurately and reduce reliance on short notice scheduling. It will be useful to have contingency plans in place for unexpected demand as well. As ever, check your policies and procedures. So do you already have a shift notice and cancellation policy in place? If so, I'll be reviewing that and looking at what you are considering that reasonable notice is. If you don't have a policy in place, get one drafted. And as soon as the regulations are in force and all the definitions are in place, then update the policies to ensure that they comply. The policies will need to include what the notice periods are, what the cancellation procedures are, and also the responsibilities of both the employer and the workers. So that is everything on the reasonable notice to provide for shifts. And I'm going to now pass you over to my colleague Katie, who will discuss the guaranteed hours. Thank you.
Thank you very much, Janie. So I'm going to be giving a short overview of what I think is one of the most significant reforms in the Employment Rights Act, which, in my view, isn't getting enough airtime at the moment. And that is the new right to guaranteed hours for casual workers. Now, the proposals that have been set out are very complicated. We're very short on time for the purposes of this talk. So it will just be a very high level overview, looking at what is the right, what do we know, what do we not know, and just touching on some likely problems and unintended consequences. So starting with what it is. So at its core, the new right is aimed at tackling what the government calls one-sided flexibility in 0 hours arrangements. Under the Act, employers will be required to offer qualifying workers a contract with guaranteed hours that reflect the hours they actually work over a period of time. So key points to know about this is that it will apply to 0 hours workers and some low hours workers. The mechanism is going to be based on a reference period, which is expected to be around 12 weeks. At the end of that period, if a worker has been working regular hours above their contractual minimum, then the employer must offer a contract reflecting those hours. Workers can either accept or decline the offer, but employers will be required to repeat the guaranteed hours offer at the end of every reference period on a rolling basis. So importantly, this isn't a ban on 0 hours contracts. Instead, what it's doing is shifting the risk away from workers by requiring employers to formalise regular working patterns where they exist. Most significantly, the obligation to make a guaranteed hours offer will also extend to agency workers, but it will be the hirer and not the agency who is required to make the guaranteed hours offer directly to the worker. So if the offer is accepted, this will result in the agency worker becoming directly engaged by the hirer. There are a number of proposed anti-avoidance mechanisms, and I'm going to touch on a few of the most significant ones. So firstly, there will be provisions in place preventing an employer from manipulating the number of hours it provides to avoid the legislation biting. Fixed-term contracts cannot be used unless it is reasonable to do so, with a presumption that it will not be reasonable if there are other permanent employees carrying out the same role. And it will not be possible to terminate a worker's engagement during a reference period, save for in 3 different circumstances. Firstly, when the worker resigns in circumstances other than where they might have what is effectively a constructive unfair dismissal claim. 2, the termination by the employer is for one of the 5 potentially fair reasons, and the employer has acted reasonably. And finally, 3, the termination occurs by virtue of a limiting event, and it was reasonable for the contract to have been entered into as a fixed term. So this effectively mirrors current unfair dismissal law that we have in place for full employees. Workers will be entitled to bring a claim in an employment tribunal and will be entitled to a declaration or compensation based on what is considered just and equitable. And workers can also bring claims for suffering a detriment for having asserted their right to guaranteed hours offers, and for automatic unfair dismissal if the engagement is terminated as a consequence. Now, Graham will be speaking a bit more about the implications of this shortly. So what do we not know? So there's a significant amount of uncertainty around some very important details of how this legislation will operate. The first is what is meant by a low hours worker. Workers who are contracted to work fewer than a set number of hours will fall within the scope of this legislation, but it's not yet known what this threshold will be. And this is critical because it will determine how many workers are likely to fall within scope of this legislation. Obviously, the higher that threshold, the greater the numbers that will be caught. Now, recent amendments in the House of Lords suggested that they're looking at perhaps 8 hours per week as being the threshold, but this has not yet been determined. Secondly, the length of the reference period. Most commentators have suggested that this will be 12 weeks, and this does seem the most likely. However, again, it's not yet been set out in the legislation. And finally, what is meant by a regular working pattern? Now, regularly working above the minimum contracted hours during a reference period will be the trigger for this duty to arise. But it's unclear how regular is going to be defined. And in particular, how will it apply to seasonal working patterns? So all of these things are subject to consultation, or will be subject to consultation. And unfortunately, we won't get any further clarity on this until that consultation process has been completed. So there are a number of issues and potential unintended consequences arising out of this. And again, I'm just going to touch on some of the most significant. So firstly, it will place a significant administrative burden on employers who will need to track hours and make guaranteed offers, particularly when each worker will need to be given an offer at different times, depending on when they commence work. Interestingly, the very fact that employers will be required to guarantee a minimum number of hours means that workers are more likely to gain the status of full employees. And this is something that Graham is going to touch on a little bit more in a moment. Businesses who have fluctuating demand for workers based on seasonality, or who have peaks and troughs, will find this particularly challenging to manage. And the fact that the right extends to agency workers and requires the hirer to make an offer of direct engagement to the agency worker is going to mean that our hirers are likely to find themselves inadvertently hiring extra workers and potentially even employees, given the increased likelihood that workers might meet the threshold of being considered employees. And in addition, there's been no indication that the government intends to make a corresponding adjustment to transfer fees, which means, as things stand at present, these could still apply where a guaranteed hours offer is accepted by an agency worker. And finally, increased wage costs arising out of this will obviously have an impact on hiring decisions, particularly for businesses with fluctuating demand. So I'm now going to hand over to Graham, who will talk in a bit more detail about the significance of some of these unintended consequences and what practical steps employers can take now to try and mitigate this impact and prepare for this legislation. So over to you, Graham.
Excellent. Thank you, Katie. Yeah, so absolutely, there are some really significant consequences and some administrative burdens that this is going to place on employers. And we are trying to think those through in the context of not yet having had a consultation on this. So, there's a lot of uncertainty, but there certainly is a lot to prepare for. Katie's mentioned there the anti-avoidance provisions, which introduce these additional rights of action. There will be a new right to bring a claim in the employment tribunal, for example, where less work is made available to a worker than otherwise would have been, either to lower the guaranteed hours offered to that worker or to try and avoid the obligation altogether. So those anti-avoidance provisions are clearly intended to increase the likelihood of workers receiving offers of guaranteed hours, and that makes sense. I mean, that's the intention here. In turn, receipt of guaranteed hours, however, is likely to increase the chances of workers establishing that they are employees for the purposes of the whole range of protections that employees have beyond the rights of workers. So, as we know, the rights that come with employment status but not with worker status include protection against unfair or constructive unfair dismissal, the right to statutory redundancy pay, minimum notice periods for termination, TUPE related protections on business transfers. And regarding unfair dismissals specifically, as we know from next year under the Employment Rights Act, there will be a reduction in the qualifying period for unfair dismissal claims from 2 years to 6 months. And there is a removal of the statutory cap on unfair dismissal compensation. So after next year, after 6 months, members of your casual workforce may well have the protections usually afforded only to those with employment status, including the right not to be unfairly dismissed or constructively unfairly dismissed. And the expansion of workers' rights in this way has, of course, been debated for quite some time as a political point. And this proposed legislation appears to be an attempt directly, or as Katie said, perhaps indirectly, to give workers some of these additional rights or the same rights and protections as employees. But currently, at least, it's quite an uncertain and perhaps confusing way to expand workers' rights. It makes it challenging, I think, for companies to understand exactly what they are required to do and to assess exactly what their exposure is. Just briefly, pausing on the test for employment status. Successfully establishing employment status, as I've said, is likely to be enhanced by workers been given guaranteed minimum hours, most likely because of the mutuality of obligation test for employment. And you may want to track the points on that and consider employment status as we prepare for the introduction of this legislation. As is often the case, there is some useful recent guidance coming from the tax tribunal. This is a topic for a webinar in itself, but you may have come across the recent judgment in the case of the professional game match officials, the Pigmole case. That's the body responsible for appointing referees, assistant referees, and VAR, video assistant referees in English football. And they are also responsible for issuing apologies for VAR errors. So they're a busy organization. And the Supreme Court referred this case back to the first tier tax tribunal on the issues of, specifically on the issues of mutuality of obligation and control, and on the question of economic dependence. And in the judgment handed down at the beginning of this month, the first tier tax tribunal ruled that there was no employment for tax purposes. And that's likely, of course, to be relevant to the employment status question for casual workers. So on mutuality of obligation, they emphasize the significant weight to be attached to the ability of referees to cancel work for any reason. And I think that seems surprising to me that referees can do that without notice. But a possible lesson here is that we ensure that even when a guaranteed hours offer is made, it's clear that workers can cancel their shifts on short notice for any reason without a penalty. It also looked at the question of control, and there are case-specific reasons regarding that, which helped Pigmole on their non-employment argument. But I think for casual workers, if it's practical, it'll be helpful to ensure that they aren't subject to appraisals, performance monitoring, or performance-related pay, all of the things which indicate control. Again, of course, that's if it's practical, which is the same with the issue of lack of economic dependence. The lesson from the Pigmole case is that for casual workers is that it's better, if possible, to not have a frequent rotation, to have a frequent rotation of workers so they don't become economically dependent on the work. And that will also, of course, assist with limiting the likelihood of a guaranteed hours order needing to be made in the first place. However, bearing in mind the anti-avoidance provision, any changes to rotas should be implemented in good time before 2027, so you can demonstrate that the structure you have in place arises out of standard business operations and isn't anti-avoidance. And as touched upon already on anti-avoidance, in any event, under the new legislation, as Katie mentioned, workers will have protection from detriment for asserting their guaranteed hours rights. And they'll have the new ability to bring employment tribunal claims where there is alleged manipulation of their hours to avoid the obligations. So this creates an entitlement for workers to claim compensation for the detriment that they've suffered. What about where that detriment involves termination of their contract? Well, again, as Katie touched upon, Section 27 of the EIRA will provide that it'll also be automatically unfair to dismiss an employee if the reason or the principal reason is that the employer or the company sought to avoid compliance with the duty to offer guaranteed hours in relation to a particular reference period. So there is this new automatically unfair dismissal claim, which doesn't require any qualifying period of service. So, and we're talking about workers, it appears there isn't a need here to actually establish employment status because it's framed as applying to workers. So in those circumstances, it would seem, at least at the moment, the workers may be able to bring an unfair dismissal claim after 12 weeks, the relevant reference period, which is obviously a significantly increased exposure. So the next slide, just some practical points before I look at the questions. This applies, I think, to everything that's been said. These practical points worth thinking about. First of all, potentially auditing your current workforce, identify where you are using 0 hours or low hours contracts, and which workers are working regular patterns. You can identify that now, because those individuals are most likely to qualify for guaranteed hours offers. You can start tracking working time properly if you don't already. It's built around this 12-week, well, a reference period, which we think will likely be around 12 weeks. So you need accurate data. Review your contracts and policies and any commercial agreements you have with employment agencies, and consider a review now of the employment status of your casual workers in line with what I've just discussed. The recent Pigmore case on that may assist with that analysis. Assess the operational impact, obviously potentially very significant. Consider how guaranteed hours will affect your staffing models, your peak demand coverage, and your labour costs. Not on the slide there, but I think it's probably important as well to think about training your managers so they understand when a worker becomes eligible and how to handle guaranteed minimum offers being made and how to avoid inadvertently creating regular patterns without planning for the consequences. And I think finally, it makes sense to engage in the consultation process. As we've said, that hasn't yet commenced. It was due to be completed in autumn of last year, but it's yet to start. And it will give you an opportunity to voice your opinions and to express your concerns. So we may, in the follow-up on this, be in a position to let you know when the consultation process is likely to kick off. And if you want to talk with us about getting involved in the consultation process, then please do. So looking at, that's a very quick run through some of those additional rights and protections and some of the consequences and the rather onerous burdens that are being potentially imposed upon those who engage casual workers. The Q&A, we have a few questions that have come in. One, I think, is bank worker rights to SSP. Katie, is that a question you might be able to answer?
No, I'm happy to deal with that, and I think it's a really good question because it's something that I've certainly seen a lot in practice, where there seems to be some confusion over the extent to which SSP applies to 0 hours or casual workers and 0 hours will cover bank staff. And the short answer is that workers will qualify for or be entitled to SSP where they're classed as employees for the purposes of national insurance contributions, which of course, in most cases, they will be because they're being put through payroll and there is an obligation to make NICS deductions. Now, previously, not all casual workers would qualify because they had to meet a lower earnings threshold. Since the 6th of April this year, that's been removed. So there's no qualification in terms of level of earnings. And instead, all workers, including low earners, will be entitled to at least 80% of their of an average of their pay, calculated over an 8-week period, capped at a maximum of £123.25 per week. Now, one of the things I also want to point out is obviously we probably all know under the Employment Rights Act, SSP is now a day one right, so there's no waiting period anymore. And very importantly for 0 hours workers is the issue of qualifying days. And I've seen clients caught out with this where they don't have qualifying days. So qualifying days are the days on which SSP is payable. And if you don't have your qualifying days set out in the contract, then you're at risk of the default provisions applying under the statutory sick pay regs, which can effectively mean that 0 hours workers will be entitled to sick pay for every day of the week, apart from days where no staff are required to work. And so that can be a big problem. So really important, make sure you have your qualifying days agreed and set out in your contract. So I hope that's answered the question. But if not, let me know.
Fantastic. Okay, we're coming up to the end of our allotted time, but just briefly, there's a question there about 0 hour workers, where there's a team of 0 hour workers, but for summer projects such as staffing of Wimbledon, which is a 2-week tournament, they choose when they want to work via text. So there's a question there as to how they can protect themselves. Is that something, Janie, that you might comment upon?
Apologies, muted. Yeah, I think this is going to be a really tricky area to navigate. And I think until we have a better understanding of what is going to be considered reasonable notice under the regulations, we won't fully know how this will work in practice. However, we do know at this stage that if a worker requests to work a shift themselves, then the notice to give that shift doesn't apply. But then obviously the notice of the cancellation will apply. And again, in that situation where you've got an employer offering one shift to multiple workers and then it's only taken up obviously by one worker, what happens to the others who have agreed to work it? Because that is going to be considered a cancellation and most likely without notice. So I think until once we know what a reasonable notice means, we'll have a better idea. But I think policies will be really important, and also think about the ways in which shifts are offered or at least presented to a group of workers. Because although we know that if I think it's going to be really difficult, because even if there's no notice even if you don't have to provide notice for the shift, and if an employee requests it, it looks like there will be liabilities involved when it's cancelled. So again, understanding what resources you're going to need, so how many people are going to be on the shift. There's going to be a lot of emphasis on forecasting and planning in a way that will hopefully reduce the need for cancellations. But unfortunately, as the regulations are drafted, I don't know yet how we can get around the non-cancellation of shifts. So I think it's all going to be about planning and trying to do what you can to reduce the need to cancel shifts.
I think the practicality point there is something that maybe for the consultation to raise the issue with the lack of practicality of that. We are out of time. There's a couple of very good questions on the Q&A. Claudine has asked questions which some of it covers the reasonable notice point. I don't know, Katie, if you can see the second in terms of guaranteed hours, how this would work for agency staff in a term time setting.
Sure. So very good question, Claudine. So I think what you're talking about there potentially is the use of fixed term contracts. And as the legislation is drafted at the moment, fixed term contracts can be used, but only if it is reasonable to do so. So there's two elements to this. The first is there's a presumption it will not be reasonable if you have other full-time employees or permanent members of staff who are doing the same role. So the first question is, with your agency staff, is to look at, are they doing the same role as any permanent work employees, in which case it's going, there may be problems there with justifying the fixed term. Secondly, the fixed term contract can also only be used where there is a specific need for a short-term task. And, clearly, if you only require staff for term times because of the way that schools and education is structured, then I think definitely it would satisfy that second point. So you would be able to demonstrate that it is fixed term is necessary because you only require for a specific period of time. I would imagine again that even if you have a agency staff and full-time members of staff, the full-time members of staff probably are also only needed for term times. So, in that case, I think you should be absolutely fine. But it is something to look at.
Very briefly, then, to finish, there's a couple of questions there. One from Hannah and one from someone who prefers to remain anonymous, which are about whether this will apply to casual worker contracts where there's no mutuality of obligation. And hopefully I didn't confuse things by talking about the test for employment, which is a question of a sort of additional consequence of all of this where employment status may be established. But I think the answer to both of those questions is yes. Katie, is there anything?
I think I would add in respect of Hannah's question. So yes, an anonymous attendee,
Yeah.
it does apply to all casual workers regardless of whether there's mutuality of obligation or not. The point was that having to make a guaranteed hours offer potentially creates that mutuality of obligation.
Yeah, exactly.
The second question, or Hannah's casual workers with no minimum set hours and want to keep it completely flexible. So what's going to be relevant to you here, Hannah, is the threshold that they set for when a worker will be caught by this. So if you have, so let's, for argument's sake, and we don't know this is the case, but for argument's sake, if the threshold is working hours that are 8 hours per week or less is the threshold, provided your casual workers are working over 8 hours, then they won't be caught by this legislation. You can still keep that flexibility. But if they are 8 hours or under, then the legislation will bite. The next question for you will then be, how can we reduce the regularity? Because the second issue is going to be, if they are working regularly and they accrue a regular working pattern, then again, that's when you're going to be obliged to offer a guaranteed minimum hours contract. So it's going to be about how can we, and when Graham was talking about frequent rotation of workers, how can we reduce that regularity to make sure we keep that flexibility and we're not obliged to make these guaranteed hours offers? So I hope
Fantastic.
that answers both questions.
Thank you, Katie. Obviously we're a few minutes over, so I have to end it there. But hopefully you found that very useful. There's a lot of uncertainty, a lot of potentially significantly onerous obligations that are going to be imposed through this. So I think the thing to do is to keep in touch with us. Let us know if you have any specific concerns. We're here to help, and hopefully you found that useful. Thank you.
Thanks, everyone. Bye-bye.
Thank you.